Hey, welcome. This is a Disability Law Show. As you know, welcome to it, and I hope you stick around for the entire 30 minutes. Lots to learn here. As always, Sivan Tumarkin right beside me, doing all the heavy lifting. I'll tell you how to reach out right off the top, 1-855-821-5900, help@disabilityrights.ca as well. Coming up on the show today, 5 fast facts about disability law claims. That is on the way, Sivan. But first, the week that was. What's been happening with you this past week?
Well, John, I had an interesting conversation this week with a gentleman who called me. He lives just outside of Vancouver in BC, and he's a mechanic by trade. He's 48 years old. He's got a couple of kids at home, and he's suffering from pretty bad sciatica, back pains. He also has migraines, and he's been seeing a bunch of doctors. And you know, that's led him to take time off work, and initially he was on short-term disability. Then he was on long-term disability for just over a year or so. And then he got this phone call from his adjuster, from his long-term disability adjuster, saying, we want you to be seen by one of our doctors for an IME. And for anyone who's tuning in for the first time, an IME in the insurance context means independent medical examination. I can tell you right now that these assessments by insurance doctors are anything but independent. And I'm saying this not only as a lawyer that deals in this area of law and has seen many, many cases like this, many assessments that have come to the wrong conclusions by these doctors hired by insurance companies. But in addition to that, you know, I can tell you that having worked for the insurance industry in the past, in the distant past, having protected insurance companies, I would often, schedule these kinds of assessments on cases where I was defending the insurance company. And I'll tell you this, John, I would not schedule a person to go see one of these insurance doctors unless I was fairly confident that I would get a report that's favorable to the insurance company. Now, I know we're not supposed to be saying this. You know, this is why lawyers, I guess, have a bad reputation in some instances, and insurance companies as well. But the reality is I had a job to do, and that was to protect the insurance company that I was defending. Well, look, when we now deal with these kinds of claims, like this gentleman who had called me this week, and he's telling me that he's scheduled to go see this independent medical assessor, you know, immediately that's a red flag. Now, you have to see one of these assessors, or you have to undergo one of these assessments if, in fact, you have a disability claim, a long-term disability claim, because under your policy, it stipulates that you have an obligation to comply with such a request. It's not an unlimited thing. It's not as though, you know, you need to go through 1,500 of these kinds of assessments. But if they want you to be seen by one of their doctors, you do have to comply. You should tell the truth when you go to one of these assessments. You should provide as accurate information as you can. But the reality is that the insurance company is sending you to one of their doctors that they're paying for these assessments because they're hoping to get a report back from that assessor that says that you are not as disabled as your doctors are saying that you are. In other words, they're hoping to get a report that they can use to then cut off your benefits. And, you know, I know that's scary, but as long as you're prepared for that and we can figure out how to maneuver around that, at least you know what your options are if that in fact happens. And so I told this gentleman, I told him what to do. I gave him some tips, which I do quite frequently when people call me about this issue. And I told him, look, at the end of the day, after you go through this assessment, ask your adjuster for a copy of the report from this assessor and make sure you go through it with a fine-tooth comb. And if that assessor comes to a conclusion that contradicts what your own doctors are saying, well, then give that report to your doctors and have them provide a rebuttal or a response. And at least that way we have the record here. We have everything on the record. And if the insurance company latches on to that opinion from their paid doctor, this assessor, this independent assessor, and cut off your benefits as a result, well, trust me, we can help you. We'll be able to help you with the help of your doctors. We'll be able to force the insurance company to pay you what you're owed.
Let me ask you 2 quick questions in that regard. You said, you know, they'll send you to see one of their doctors. Well, I mean, during COVID, that's probably not going to happen. Can they do a paper assessment? And sometimes it's a medical consultant, which I'm not sure what a medical consultant is, because if it was a doctor, they would probably say doctor. But what do you think about both those questions?
Excellent question. So number one, insurance companies, you're right, John, sometimes will not even send you to an assessor. And now during COVID, some of these assessments are even done online by WebEx or Skype or some other, way. But if they don't do that, sometimes what they do is they give your medical file to one of their consultants. Sometimes that consultant is an MD, a doctor, sometimes they're not. But the reality is, and I can tell you, there have been court cases where judges have essentially poo-pooed, these paper reviews. Because on the one side, you have your doctors that know you, have been treating you, and they're saying you're disabled. And on the other hand, you have these people, these assessors that the insurance company hires to review your medical file and then come up with their own opinions and conclusions, which may contradict what your own doctors are saying. Well, if you think about that, where is there more credibility? With these individuals who have never seen you or talked to you, who are now saying that based on their review of your medical file, you're able to work and should not get LTD benefits? Or is there more credibility with your own doctors who have been treating you, who have your best interests at heart? I can tell you, John, I think that the individual's doctors are at the end of the day going to trump, right? I mean, they're the ones that I think a judge or a court will hear and will be persuaded by. Now, to your other question here, some of these assessors are not doctors. So with this example here, with this gentleman who called me up, the mechanic, well, you know what? He has a chronic pain doctor. He has a family doctor, and I think he was about to go see a neurologist because they thought that there might be a nerve impingement. And my understanding is that the individual that he's supposed to go to an assessment with is just a general practitioner. In other words, it's somebody that is a family doctor. Nothing against family doctors, but sometimes the insurance companies choose the wrong assessors. Sometimes they don't even choose doctors. They'll choose people who have some kind of an experience in the medical field, a physiotherapist, a chiropractor, but not an MD. So again, you have to be cognizant of who it is that you're being sent to. There's nothing wrong with asking your adjuster to give you information about the assessor, for you to look them up, to understand what their credentials are. Because at the end of the day, if the insurance company is going to make decisions with respect to your case based on someone's opinion, that opinion better be relevant. It better be rooted in somebody who has expertise in the disability for which you are getting paid.
I want to bring up another website, pocketemploymentlawyer.ca. Normally we talk about that in depth on the Employment Law Show, our other show that we do with Lior, of course. But there is a section in that website, as robust as it is, on disability law as well, right?
Yeah, there is, absolutely. We created this tool. This was Lior's brainchild, the employment lawyer. The idea was to give people the ability to get accurate, fast information online through this tool about their employment issues. But guess what, John? Many people who contact our firm, because we do both employment law and long-term disability law, they have issues with their long-term disability insurers. And so they go to the Pocket Employment Lawyer, not only to get answers about their issues with respect to their employment, but also with respect to any issues they may have with their long-term disability insurance claim. And again, this is a free tool. If at the end of it you get your answers, you want to contact us, you want to get more information about your specific situation and speak with somebody on our team, by all means you can click the button and the contact will be made. But it's a really, really cool tool, and there's nothing really like it. You can go to websites all over the country to try and get information about employment law and disability law. But the Pocket Employment Lawyer is exactly what it is. It's the Pocket Employment Lawyer. The idea is it allows you to get answers to your specific questions in relation to your specific situation, be it employment related or long-term disability related.
Let's get to a quick email here. Sivan, I'll get you to answer this one. help@disabilityrights.ca is the way you write into the show, or Sivan, his team, anytime for that matter. Kayla says, my brother's been rejected twice by his LTD insurance company because they say that his disability is not serious enough and that he can do his job. He has chronic pain, and his doctor says that he can't work because of back issues that go back to a skiing accident. What can he do?
Well, look, Kayla, the reality is that he has an entitlement to these LTD benefits. If the doctors are saying that he cannot work because of these impairments, which are impairing his ability to work, then he has an entitlement. He should be getting LTD. And John, when an insurance company says you don't have enough medical documentation to prove that you are totally disabled under the policy, what they are doing essentially is telling you that they don't buy what you're selling. They're not buying what your doctors are selling. And they can't do that. I know that they do this each and every day. I know that people out there who are probably listening to me are thinking, yeah, but hold on, being totally disabled under the policy must mean something extremely serious. Must mean that you're brain dead or you're in a coma. No, it means nothing of the sort. It means nothing of the sort. If at the end of the day you cannot do the essential tasks of your own occupation for the first 2 years of LTD, or any occupation for which you're suited for after those 2 years, after the initial 2 years, and your doctors confirm that you in fact are unable to do those essential tasks, well, guess what? You should get LTD. Okay? None of that nonsense from insurance companies that, you just don't have enough information, you haven't given us enough. Now look, if all you've given the insurance company is a scribble on a napkin from your doctor saying the person needs time off, well, that's not enough. But if your doctor or doctors have provided reports, letters, where they outline and explain what is in fact disabling you, what are the symptoms, how are those symptoms functionally impairing your ability to work, the insurance company must pay you LTD. And if they don't, that's when you contact us. Because really, John, it'll take us only a few minutes of reviewing those documents to tell you if in fact the insurance company is correct or not correct. But I'll tell you, when people contact us, it's usually because they know something is wrong. They know that there is an issue here with how they've been treated by their insurance company, and that's when we jump into the picture. That's when we help them force their insurance companies, pay them what they're owed.
All right, quick break, and we'll tackle this afterwards, as I mentioned off the top. 5 fast facts about long-term disability claims. That is coming up on the Disability Law Show. You want to reach out anytime. The phone number, 1-855-821-5900 and disabilityrights.ca. Don't go anywhere. We're coming right back. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, thanks for hanging around. Disability Law Show, John Scholes, Sivan Tumarkin, and we're going to get to this. Strap in, pal. We're going to get to these quickly. There are the 5 fast facts about disability law claims. Number 1, Sivan, is this. If your legitimate disability claim is denied or cut off, there is something you can do about it. You bet there is.
Yeah, and John, I want to emphasize the word legitimate. And what I mean by that is not that it has to be, ultra severe. That's not what I mean. I mean that we have a reputation to uphold. Insurance companies know that when we represent a claimant, it's because we believe in that claim. It's because we believe that the person is legitimately disabled. And look, there are people out there who are trying to game the system. And if that's why you're calling us, you're going to be sorely disappointed, because we don't like to do that. I certainly understand insurance companies' apprehension when they're looking at some claims and when they think that some individuals are, again, trying to game the system and just get money that they're not really owed. But if you are disabled and you're unable to do the essential tasks of your own occupation or any occupation, again, depending where you are on the policy, and your doctors confirm that, and despite all of that, the insurance company says no, that's when you contact us by email, by phone, on our website, whatever, just to get the information you need. Okay? The worst thing that a person can do, as far as I'm concerned, John, when they have a legitimate claim for LTD, is not pursue it. And since we've launched this TV show and radio show for years and years and years, right? We've been doing this, I think, 7 or 8 years or so. I can tell you, I have had people contact me who have been denied their legitimate claims 10 years ago, 15 years ago, 5 years ago, and they said, if only we knew, if only we saw your show back then, if only we understood what our rights were, can we do anything about that now? Well, unfortunately, no. If you haven't started a claim within that limitation period, right, because there is a limitation period for starting legal claims in most jurisdictions, in every jurisdiction, actually, practically in Canada, and generally it's 2 years, depending on where you are, but it's usually 2 years from when you were first denied your LTD claim. If you haven't started that legal claim, you're out of time, or potentially out of time, okay? There are some exceptions, but they're very rare. So again, do not walk away from money that is owed to you. Get the information you need. It doesn't cost anything to speak with a member of our team, okay? That's really, really important. We're not charging anything up front.
Fast fact number 2 is this: your insurance company cannot ignore medical information supplied by your doctors that support your disability.
Well, they try to, and many times that's the basis for their denials. They're saying there's insufficient medical documentation, we disagree with Dr. So-and-so, our doctors think something different. It doesn't matter. It doesn't matter. If you have doctors, and when I mean doctors, I say family doctor, chronic pain doctor, psychiatrist, psychologist, when you have people treating you, health providers, and they confirm that you are disabled from working, well, then guess what? The insurance company doesn't have the luxury or the ability to simply ignore those opinions. They may disagree with them. I've seen this happen on numerous occasions where the adjuster simply says, I just don't believe what the doctor's saying. I don't care. I don't care. As long as your doctors believe in their opinions and they have a legitimate reason to do so, right? And they confirm that you've been following treatment recommendations and you still cannot work at the present time, well, guess what? The insurance company must pay you. And again, if they don't, that's when you reach out to us and we'll tell you what can be done next.
We are going through the 5 fast facts about your disability law claim. Number 3 is this: event. The insurance company will not have the right to stop your disability benefits if you do not try to go back to work.
Yeah, this is really, really key, especially now during COVID, by the way.
Yeah.
Insurance companies oftentimes will pay you long-term disability benefits, and at some point, your adjuster will start saying things like, maybe it's time for you to try to go back to work. What do your doctors think about that? Mm-hmm. We want you to be seen by one of our assessors for an IME. And the IME doctor that they send you to says, it's time to try a return to work program. You have zero obligation to try to go back to work if you are not ready and if you do not get medical clearance from your own doctors. Period. Full stop. And if the insurance company is trying to force you, okay, or they're trying to strong-arm you into going to work, and they're telling you that if you don't try return to work program by a certain date, they're going to cut off your benefits, well, guess what? You should be reaching out to us. Because at that point, either we get involved or we'll tell you, based on your specific situation, what you can do to protect your rights. The insurance company cannot force you to do something that harms your health. They cannot do that. Now, why it is that they want you to go back to work? Because they want to stop paying you. They're not interested in continuing to pay you LTD every single month. So if they think that they can somehow strong-arm you, persuade you, do whatever they can to force you somehow to go back to work, well, that's great, because then they get not to pay you. But they cannot do that if you're not ready. It's that simple.
Fast fact number 4 is appealing long-term disability claims is often a waste of time. Quite often. How about that? Quite often a waste of time.
It's quite often a waste of time, exactly. These appeals are internal processes that the insurance companies have set up in order to have you go in a merry-go-round, okay? They'll deny your claim or they'll cut off your LTD, and in that letter that they send you, there's usually a paragraph or 2 at the bottom that explains to you your right to appeal, and it makes it look formal. If you disagree with us, but you have more information, more documentation, by all means, give it to us. We'll reconsider it. We'll think about it. Maybe we'll reverse our decision. I'm not saying that they put that there, but that's what they want you to think. They want you to think that this appeal process is somehow some kind of a third-party, neutral, fair, objective process. It is not. You are essentially re-asking the exact same company to reconsider their decision to stop your benefits or to reconsider paying your benefits if they haven't paid you in the first place. And most of the time, I say most because nothing is a certainty, most of the time, those result in denials. Denial after denial after denial. And that's when, John, I have people contacting me a year or 2 years after they were first cut off or denied their LTD, saying I was denied twice, 3 times, 4 times. What are my options? And I explained to them that the option is to start that legal process, the legal claim, and generally we resolve these kinds of cases fairly quickly. And the irony here is this. In some of these cases, we've resolved cases literally within weeks, if not sometimes months, but weeks sometimes, of being retained to deal with the insurance company. And that's in situations where this individual or individuals have appealed and reappealed over and over and over, and so they've wasted time, precious time. Instead, if you are denied or cut off LTD, you should reach out to us immediately because we can take action now.
We'll get to the last of the 5 facts before we break. Savannah, is this: choosing the right disability lawyer, the right team, the right firm will help you get the compensation you're owed, you're deserved, without any upfront costs.
So listen, let's be clear here. I'm a lawyer. I'm an LTD lawyer. My team, our team of lawyers in Ontario, in BC, in Alberta, we know what we're doing. Okay, we have the expertise. Check us out. Go on the website. Look at the Google reviews that we have. Okay, we got a ton of Google reviews, 5-star reviews. There is a reason why we have a certain reputation in the industry, why insurance companies know us. But we're not the only lawyers. So yes, I would love nothing more than to help whoever, you know yourself, someone else, whoever is having difficulties with their insurance company. But we're not the only lawyers. And if you want to go to someone else, that's fine. Just make sure you choose the right person. And John, I came across this one lady earlier this week who told me about this lawyer that she had hired. She hired that lawyer 3 years ago to deal with her LTD claim, and it's still ongoing. Still ongoing after 3 years. And John, I am telling you, there's no reason for that. She has a very, very simple case. And I explained to her, I told her that really her case should have been resolved within about 6 months. Wow. And that's a tragedy because she's been without money for 3 years. Her condition deteriorated. Her doctors don't know what to do. And really, it's because the lawyer that she hired doesn't know what he is doing. So you want to make sure that if you hire someone, it's not just for LTD, by the way, employment law, real estate law, you want to make sure you get the right people. We focus at our firm only on 2 areas, employment law and long-term disability law. We don't do real estate, we don't do family, we don't do tax law, none of that. If you have an employment matter, employment issues, or you have issues with your long-term disability insurer, we are here for you. We have a very, very strong team in place to help you.
All right, short break, pal. Coming out when we come back, it's going to be, do you have to agree to an independent medical assessment? We'll tackle that after a break. 1-855-821-5900 and disabilityrights.ca. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you. They may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Thanks for sticking around. Disability Law Show. I want to give you the address of another resource you can use anytime. We refer to it at every show, mydisabilityquestions.com. You can ask your questions right there. They will be answered by Sivan, a member of his team. And there's a searchable database as well, so you can search for a question similar to yours that you're about to ask and see if it has been answered already. Read it. If it has, not satisfactory, leave your question there and they'll get to it. Sivan, the first one for today, or at least another one for today, from Adrian this time, says, I went off work due to workplace harassment and a toxic work environment. With my psychiatrist and psychologist support, I was eventually approved for LTD. I'm now almost at the 2-year mark of medical leave, my medical leave. The insurance company is now requesting that I go through an independent medical assessment. Do I have to agree with this request?
Yes, Adrian, you do. And we talked about this. Under your LTD policy, there's likely a provision in there that obligates you to comply with this kind of a request when the insurance company wants you to be seen by one of their assessors. Of course, it's called an independent medical examination. It's nothing but independent because the doctor you're going to be seeing is paid by the insurance company. Now, what's interesting here, John, is that he's being asked to undergo this assessment at the 2-year mark, or almost at the 2-year mark. And I want to make sure people understand this, that in many, many cases that we see at our office, and just generally, actually, I can tell you anecdotally, that individuals get cut off LTD around that 2-year mark. Why is that? Why is it that after 2 years of getting LTD, suddenly the insurance company says you no longer qualify? Well, that's because the majority of LTD policies out there distinguish between the test. There's a different test to get LTD for the first 2 years and a different test after the 2-year mark. So for the first 2 years, you have to demonstrate with the help of your doctors that you cannot do the essential tasks of your own occupation. Beyond the 2-year mark, the test is a bit more difficult. It expands. The test is, can you do the essential tasks of any occupation for which you are suited for by training, education, or experience? So in Adrian's case here, the insurance company is clearly fishing through this independent, quote-unquote, medical examination for an opinion from that assessor to disqualify him from getting LTD benefits beyond that 2-year mark. Well, if, in fact, his own psychiatrist, his own doctors confirm that he cannot do any other occupation, okay, at this point in time, for which he's suitable, well, guess what? I don't care what this independent medical assessor says. He should continue getting LTD beyond the 2-year mark. And if he doesn't, if he gets cut off, or if he's told that the benefits will end, he should be contacting us. So Adrian, please reach out to us if, in fact, the insurance company tells you that as a result of this IME, this assessment, they will end your benefits at that 2-year mark. Especially, of course, if your own doctors say, no, you cannot work. You're not ready to go back to any occupation. We will be able to help you.
Let me ask you two related questions to this. I know we've got about 3 minutes to go, but I'll ask them anyway. First one, briefly about the concept of totally disabled when you first go on LTD. And then if you are able to go back to work, the concept of commensurate income, because you can't ignore that as well, right?
No, absolutely. Absolutely correct, John. So, I mean, first of all, totally disabled, again, it is an invented term. Many people get taken aback, not just individuals who are applying for disability, but doctors, therapists, people who are dealing with long-term disability policies. What they see is the insurance company saying that you have to be totally disabled to qualify for LTD. And when they think of total disability, the word total, that implies catastrophic. That implies complete, like you're brain dead. No, it's not that. It is simply a term invented by the insurance industry, I think, to thwart people with legitimate claims from applying for LTD. And frankly, I've even seen doctors who've told their patients, don't bother applying because you're not totally disabled, assuming we use the word total in the way that you and I use it, John. In the LTD context, all that it means, total disability, all it means is that you cannot do the essential tasks of your own occupation. So if you're suffering from anxiety or depression, you can't get out of bed, you are totally disabled potentially from working, from doing the essential tasks of your own employment. And again, it depends on what your doctors are saying about that. So that's really, really important to understand, John. Very, very important. Now, when an insurance company says at the 2-year mark that they think that you can do some other occupation, in other words, that you will not meet the definition for total disability beyond the 2-year mark, what they have to show is that you can do some other occupation, some other job that will pay you, as you said, John, commensurate income. Mm-hmm. Courts have interpreted that to say 60, 65, sometimes 70% of your pre-disability income. If you cannot get another job that will pay you that, well, guess what? You should qualify for LTD beyond the 2-year mark. So a very simple example, let's say that you are making $100,000 a year. You've become disabled for whatever reason. It's a physical injury or illness or psychological. And you've been getting LTD now, okay, for 2 years. At the 2-year mark, the insurance company says, we think that you can do some other occupation. Guess what? If you cannot get another job that pays you $60,000, $65,000, $70,000 a year, you should continue getting LTD. And if they tell you that you're not going to get it, give us a call immediately because we can help you.
Done for another week. Fantastic stuff. 1-855-821-5900. help@disabilityrights.ca is the email address. Disabilityrights.ca is a link to the radio shows, and we always use it, mydisabilityquestions.com as well. See you next time. Disability Law Show.